Yeah.
I think he's now going to be based in Korea
Right.
again, but he'll be traveling to Singapore quite frequently.
Yeah, he does because he's got an office here.
That's
Yeah.
correct.
Yeah. No, I mean, we because he's a vegetarian, so I enjoy having lunch with him once in a while. I mean, I'm not vegetarian, but
Ah,
so yeah. His
yeah.
wife is Korean, as you
Yes,
know,
yes, that's correct.
Yeah.
His vegetarian diet sometimes allows me to actually get out of the meat world from time to time, so that's good.
Okay. Great. So I see you're presiding in this one. Huh? Okay, my role was just to watch and decide on the, what is called, I mean, rather the top advocate or counsel concern. So basically, that's my role here. So easy.
So, good evening, good afternoon, and good morning. Let me welcome you to the final of the 2022 FDI Moot Regional, where we will be hearing Team Wellington representing claimant against Team Kirsch representing respondent before a tribunal of Mr. Steve Kim, General Secretary of the KCAB International as presiding arbitrator, Mr. Jae Hyuk Lee, foreign attorney at the international arbitration law firm Peter and Kim, and Mr. Ian Chiang, an associate at Gauss in Singapore, one of our top FDI Moot alumni and one of the designers of this year's FDI Moot case. We will also have a board of assessors with Mr. Aziz Tayabali, Mr. Frederick Lindmark, and Ms. Apurva Dixit determining the best individual advocate of the final. And with that, I would ask the assessors to turn off their cameras, which I will also do now, and I will invite the presiding arbitrator to commence proceedings.
Christian, thank you very much. Ladies and gentlemen, welcome to the final round. My name is Steve Kim. It's an honor to serve as a panel member here. I'm sure you've done a tremendous amount of preparation. There are a number of issues where the committee has designed for you to actually consider a number of sub-issues as well. I obviously review the facts and the issues as well, and they are challenging nevertheless. So I would welcome for you to be creative and obviously represent your clients with a certain amount of zealousy as well. So I'd like to actually begin this round with just a couple of household issues in terms of have the council agreed on who's going to go first, who's going to be the time allotment and all of that? Has all of that been cleared and in order? Could I ask Team Wellington to confirm?
Mr. President, it has been agreed upon and the time allocation and order of arguments are in the chat.
Okay, that's fine. Thank you very much. Okay, I'm just going to take a quick look. Okay, that's fine. Great. Good. In view of the time limitations that we have, I'd like to go ahead and ask the countess to start the proceedings, please.
Mr. President, before the proceedings begin, may I just ask the panel of arbitrators if when we cite the moot problem, whether it would be better to cite the PDF pagination or the physical copy pagination?
Ian, do you have any thoughts on that?
I have no firm preference, but perhaps the PDF would be easier, perhaps.
That's fine. Let's
Certainly,
go ahead and use the
thank you.
PDF as the reference point.
Hi, members of the tribunal. Is it my turn to begin?
Yes, go ahead and start the proceedings. Thank you.
Thank you very much, Mr. President. May it please this tribunal, my name is Jae Lim, and I appear on behalf of the respondent. I'll be speaking on issues of jurisdiction for 19 minutes, respectfully leaving 1 minute for rebuttals. My colleague Jerome will bring you through the substantive points later on. Members of the tribunal, there are 3 pertinent facts in this case. Firstly, the shareholders of Sutton Holdings, Daisy and Donald, commenced a prior claim 5 years ago in 2017. Second, this claim was dismissed both by the Rican courts and the Exit Tribunal in Donald and Daisy against Rekia. And thirdly, the claimants have not yet submitted a claim to Rekia's domestic courts. It is my case that the present proceedings cannot continue due to a lack of jurisdiction. I make 2 legal points. Firstly, res judicata applies to preclude a claim as the test is fully satisfied. And second, that the claimant is barred from continuing with its claim as it has not yet exhausted local remedies. Moving on to the first point, the respondent acknowledges that the triple identity test is the one most commonly applied in the context of res judicata. According to the 2014 exit case of Apotex Holdings, once the case has been decided by a valid and final judgment, the same issue may not be disputed again between the same parties, as long as that judgment stands. And theoretically, there must be identity of object, cause of action, and persona. Moving on first to the same parties limb. All parties of the subsequent proceedings, the present proceedings, must either be parties to the prior decision, successors, or privies, and privity requires a certain proximity, which is fulfilled in this case. The claimant's majority shareholders, Daisy and Donald, should be considered privies of the claimant. Under the BIT, they were able to commence proceedings against Rekia for loss to their investments. As the tribunal in the 2017 exit case of Ampal noted, one of the consequences of that is that the investor or shareholder is treated as a privy to the investment company for the purposes of the rule of res judicata. Members of the tribunal, this must be the case because otherwise, the shareholders will be taking the benefit of an extended right of action without bearing the burden of being bound by any finding arising out of a claim by the investment company itself on the same facts.
Excuse me, counsel. Excuse me, yes. Sorry to interrupt you, but I have a question. So on page 33 of the physical copy, which would be like page 36 of the PDF file, on paragraph 12, it says that they were subjected to substantial interference with its rights. So what was their claim? Was it more about the shareholders' rights claim rather than the loss of investment claim? So could you clarify more, please?
Sorry, Mr. Arbitrator, just to clarify the question, you're asking about whether or not it was an interference to their investments versus an interference with their rights as investors?
So my question is whether they claimed, as you submitted, whether they claimed the loss of investment or whether they were just claiming for their rights as shareholders.
I believe, Mr. Arbitrator, that they were claiming for the loss to their investments because they were claiming for a diminution in the value of their shares. So there are 3 common threads in the shareholders' claim and the current one. So apologies. Let me gather my thoughts for a while. So the 3 common threads are salient. So firstly, there was negligence on Rekia's part alleged. Second, there was damage to Sutton Investments property in the form of destruction on their cannabis plants. And third, an impact on their investments. And therefore, we feel that res judicata should be binding on claims arising from Rekia's acts with regard to the civil war and its result on the claimant's properties because the previous claim and the current claim both emanate from the same breach. If there are no further questions, with the permission of the tribunal.
Counsel, if I may, I just have a question for you. So I understood your argument to mean that as long as it's a shareholder of the claimant, that is enough to make him or her a sort of party to the claim as well. But is there a threshold? Because it can't be the case that every shareholder would also amount to the same unity of identity, right? Is there a threshold in terms of percentage of shareholding? And even so, does it matter that there was no coordination between Donald and Daisy and the claimant?
I take your question, Mr. Arbitrator. So I will address the two questions in turn. First regarding the threshold and the second regarding whether or not the lack of coordination matters. With regard to the threshold, we propose that the threshold should be a majority or controlling shareholder. In this case, Donald and Daisy collectively own 75% of the shareholding in Sutton Holdings. And that means that in effect, they control the company. And this is a factor in choosing to pierce the corporate veil. With regard to coordination, it is acknowledged by the respondent that Donald and Daisy did not consult the company in its previous claim. However, in their previous claim. However, in the current case, as majority shareholders, it stands to reason that for the company to bring a claim, they would have needed the approval of Donald and Daisy. Therefore, there is a possibility that they will be pursuing this current claim after having failed the first time as an opportunity to use the corporation's rights as both a sword and shield. And members of the tribunal, this is a policy that, members of the tribunal, the policy that shareholders should not be able to use the corporation's rights as both sword and shield. Members of the tribunal, let me gather my thoughts. Defending against this abuse of process is something that the tribunal should be upholding against. If there are no further questions, I will continue with my submissions, if that's okay. Thank you, tribunal. So in the present case, the shareholders' claims only existed through the claimant in respect of the claimant's commercial activities, and this is reflected in the shareholders' claim for damages sustained due to the diminution of the value of their shares as a result of the damages sustained by the claimant. Therefore, the shareholders and the claimant should be considered effectively the same person, fulfilling the persona limb of the triple identity test. Moving on to the limbs of...
Excuse me, counsel. So theoretically, so what would be the rights that the remaining 20 shareholders who hold the remaining 25% of the shares have? Like, do they have any, like, what kind of relief can they claim, in your opinion?
Minority shareholders have direct standing to claim for a breach of the BIT. And if the tribunal will turn with me to page 79 of the agreed bundle, this is the BIT Article 13, paragraph 7. It's at the bottom of the page. Is the tribunal with me? Okay, great. So over there, it states that minority non-controlling shareholders have direct standing to claim for any direct loss or damage to their own legal interests as investors. So the minority shareholders are not prejudiced. So moving on with my submissions to the limbs of object and cause of action, the respondent notes that while they are technically two separate limbs, tribunals have in practice applied them together. And this was observed by the 2014 exit case of Apotex Holdings. Thus, the previous case and the current one must be regarding the same question as previously decided. Therefore, even if the second suit is for a different cause of action, the right question or fact, once so determined, must be taken as conclusively established as long as the judgment in the first suit remains unmodified. Furthermore, this is to be preferred due to policy reasons. The same case of Apotex noted that if only an exactly identical object based on the exact same grounds can preclude a second case due to res judicata, litigants could easily evade this by slightly modifying either the relief requested or the grounds relied upon. Applying this test to the present case, the material facts brought before the prior tribunal in Donald and Daisy against Rekia and the current claim are identical. In the prior award, as I mentioned earlier, there are three common threads of Rekia's negligence, damage to certain investments property, and an impact on their investments. Both claims emanate from the same breach, and this is a form of functional identity that suffices to fulfill the test. As a last additional point to my res judicata arguments, the claimant may argue that res judicata cannot be invoked because the tribunal in Donald and Daisy lack jurisdiction. However, Donald and Daisy is a final and binding award. It is without question that the finality of Donald and Daisy has not been affected by annulment. Moving on to my second argument on the exhaustion of local remedies, this is an alternative to my previous argument on res judicata. Firstly, the BIT clearly requires the exhaustion of local remedies as a mandatory precondition for the commencement of an exit arbitration. And a number of investment tribunals have treated the local remedies rule as a mandatory jurisdictional condition pertaining to the state's consent to arbitration. Furthermore, 18 months must have passed from the time an investor submits the dispute to the judicial bodies of a contracting party. If the tribunal will turn with me to page 77 of the agreed bundle at Article 12, subsection 2, near the bottom of the page. Is the tribunal with me? This is a necessary condition supported by the language of the treaty because the BIT states that the dispute shall not be referred to arbitration unless 18 months have passed. This language suggests that the contracting parties wanted to give their respective courts the opportunity within the specified period of 18 months to resolve the dispute before it could be taken to international arbitration. And this right of the host state, of the contracting parties to the BIT, has been acknowledged in multiple tribunals, such as in Ombudsman Official and Ubesa and Argentina. Members of the tribunal, when concluding the BIT, this article was willingly submitted to as a condition. However, as the claimant itself knows, it has not yet submitted the dispute to any of Rekia's judicial bodies. They could have submitted a claim in Rekian courts and waited for the 18-month period to expire, but failed to do so as required by the BIT. Furthermore, the futility exception does not aid the claimant. The claimant cites the test of multiple tests of regarding futility, but these thresholds have not been met. Cases where the futility exception has only applied due to undue or unjustified delays to judicial proceedings. The bar is high, and undue delay must in effect amount to a sort of denial of access to means of asserting claims. I will address 2 points regarding the futility exception. The first is on judicial deference, and the second on time delay. Firstly, regarding political deference, the present case can be distinguished from Ombudsman Official. In Ombudsman Official, the case involved the issue of futility exception because of political deference. It was clear that the courts would not have provided effective redress because there had been an established line of cases demonstrating the Argentine judiciary's unwillingness to interfere with debt restructuring decisions. However, this can be distinguished from the present case at hand. There's no evidence to show that Rekia's judiciary is unfair in its adjudication. In fact, Donald and Daisy failed at the local courts, but the exit tribunal dismissed their claim as well, and they are clearly a more neutral arbiter of the dispute.
Counsel, what about a more practical aspect to it? Do you concede that it is in practice unrealistic to expect the claimant in a more complicated case like this to obtain a full judgment from the court within the span of 18 months?
Mr. Arbitrator, the BIT does not require the claimants to obtain a full judgment. They only need to have brought their case to the courts to have commenced the claim. That is all the BIT requires.
As a follow-up then, isn't it kind of pointless and a waste of judicial and investor resources to require that you bring a claim only for it to fall short at the 18th month, and then you have to start all over again by going to arbitration? What exactly is the point of it then?
So this was considered by the Tribunal of Abesa and Argentina, and basically the BIT protects this host state's right to hear the case first. So the point is to afford the domestic courts an opportunity to attempt to resolve the claim first. And these challenges notwithstanding, the parties to the BIT agreed to include this requirement in their treaty and to defer access to international arbitration accordingly. And the case of the 2012 exit case of Ubesa in Argentina at paragraph 138 stated that although this remedy may be considered an option less favorable to arbitration, this is not what matters. And what matters is that the 18-month rule is part of the dispute resolution provision of the BIT. If there are no further questions on this point, I will continue with...
Counsel, I have a question. So in light of the so-called the cooling off provisions, how do you find this provision under Article 12 that you just mentioned? Is it a form of cooling off provision, or if it is not, what would be the difference?
Sorry, Mr. Arbitrator, I didn't quite catch your question. Could you repeat it for me? I'm so sorry.
So, Counsel, so I think that you are aware of this provision called the cooling off period provision. So I wonder whether this provision that you just mentioned under the Article 12 of the current BIT is a form of cooling off provisions, and or if it is not, so what would be the difference between a typical cooling off provision and this? What would make this provision different from a typical cooling off provision?
From what I know about similar provisions, this is a cooling off provision, and it simply provides for the period of 18 months. Perhaps a notable difference that may be observed is that a final judgment does not have to be issued by domestic courts. That is all I can point out at this juncture. Moving on to the aspect of time delay, in the 2010 Permanent Court of Arbitration case of Chevron, the backlog of cases caused by court congestion meant that the claimant's cases were delayed from being heard by 13 to 15 years. However, the average time for a case to be heard in the present case is 12 months, and this is found in Procedural Order number 3, page 90 of the agreed bundle at the bottom of the page at paragraph 9. Moreover, an expedited procedure could have been used by the claimant. Hence, the extent of delay in recreant courts are not so egregious such that it is futile or not reasonably possible for the claimant to pursue local remedies. I note that my time is up. If there are no further questions, I hereby conclude my submissions.
Counsel, just one quick follow-up question. Given the nature of damages that are being sought by the claimant and the physical destruction of the property, how would you reconcile that if, as it is listed in the BIT, 18 months goes by and then they file a local complaint to actually, should we say, to remedy the damages, that's another 12 months. That's relatively extended period of time that goes by without, let's say, shareholder, whether they're privy or not, to have any sort of option for type of remedy. How would you reconcile? Could you give your views on the reconciliation between the extent the damages suffered versus the reasonable time that one entity or a person has to file to receive some type of remedy.
Mr. Arbitrator, I note that in the current case, the breaches that occurred, the damage that happened to certain investments properties happened in the year of 2017. However, the claimants have waited 4 years to bring the present case, to bring their current claim. Therefore, despite whatever damages they have suffered, it seems, Mr. Arbitrator, that this damage suffered has not been so egregious such that they needed it to be resolved immediately, because it has been a 4-year period since the breaches occurred. If there are no further questions, I think this concludes my submissions. Thank you very much.
Okay. And the rebuttal?
Panel of arbitrators, before I begin, may I just confirm if I can be heard and I am visible?
And yes, you are visible and you can be heard.
Thank you, panel of arbitrators. Greetings, panel of arbitrators. My name is Kamal Grace Phillip, counsel for the claimants, Sutton Holdings Incorporated. Alongside me is my co-counsel, Ms. Harsha Kaur. We will both be arguing for 19 minutes in our submission and humbly reserve a minute for rebuttals. Panel of arbitrators, the case before us today concerns the claimant state that was welcomed by Rakia to invest in Rakia as part of their efforts to promote foreign investment. But due to a civil war in Rakia, all of the claimant's investments were destroyed. Yet, the respondents appear today in an attempt to absolve themselves of liability, and further they contend that this tribunal has no jurisdiction. And so we would argue the opposite, panel of arbitrators. I will be arguing on the jurisdictional grounds, while my co-counsel will argue on the merits. Without further ado, I will begin my arguments on the first ground. Panel of arbitrators, we would argue that this tribunal has jurisdiction because the res judicata doctrine does not apply. And this would be contrary to the assertion by the respondents that this claim would be barred by res judicata. My arguments will be divided into two limbs. First, a preliminary matter, which is that the previous exit decision was erroneously decided upon based on the Rakian version of the BIT. And secondly, in response to the arguments by the respondent, I will argue that the triple identity test has not been fulfilled. Panel of arbitrators, as a preliminary issue, I would like to assert that the previous decision was erroneously decided upon based on the Rakian version of the BIT when, excuse me, it is our argument that the English version of the BIT ought to prevail. And we arrive at this argument based on the interpretation rules under the Vienna Convention on the Law of Treaties, based on the negotiation process between the Athabascan and Rakian delegates. Panel of arbitrators, may I just ask if you would be interested to hear arguments as to why the English version ought to prevail, or if I should just proceed with my arguments on the triple identity test?
Ian and Jae Hyuk, do you have any thoughts? We have our notes on the plurilingual treaty issue on that.
Perhaps I was thinking that you could just briefly, in a few sentences, just address us as to why the parties envision that the English version would prevail.
Sure, Arbitrator Ian. So our arguments are simple and they are premised on 3 facts, 2 of which can be found on page 46 of the physical copy and page 49 of the PDF copy. This is in reference to the claimant's witness statement by Mr. Buncan Bagels, the Athabascan delegate. What he says on this page, specifically paragraph 8, is that the Rakian delegates were bilingual, and this was confirmed by one of them called Lisa Gunnison. And despite the fact that the Athabascan Buncan Bagels was proficient in the Rakian language, he never had to resort to using the Rakian language because all of the negotiations were done in English. Moreover, there was no accent on the Rakian delegates' tongues when they spoke in English. Moreover, if we were to look at paragraph 9, the negotiations were done on Google Drive and all the edits were done on the English draft, while the Rakian draft, no one seems to remember if it was even opened. And lastly, briefly, the respondents only raised their concern on the reflective shareholder losses at the end of the 5th round of negotiations. And this can be found on page 93, clarification 17. Moreover, despite this late arisal of an issue, during the final round of the negotiation, the need for there was no mention of the language discrepancy either. And so on those grounds, we would argue that the English version ought to prevail. Panel of arbitrators.
Excuse me, Councillor. I would like to ask a question. So I don't think that we can derogate from the Article 33 of the BCLT, which you might be aware by now. So Article 33.4 definitely talks about the reconciliation of the different different language versions of the document. So are you submitting that there's no way to reconcile both versions of the BIT?
Mr. Steve, apologies, Mr. Lee, I would like to raise the case of Kilik and Turkmenistan, where similarly there was a language discrepancy, whereby the English version contained an optional recourse to local courts, while the Russian version contained mandatory recourse to local courts, and both languages were authenticated by the parties, much like our present case. The tribunal applied Article 33, Clause 4, and found that the mandatory version would apply because it best reconciled the differences. And they arrived at this conclusion by applying Article 32 of the BCLT by looking at the supplementary means. And that is what we implore this tribunal to do as well. And so if I may move on to our arguments on the triple identity test in response to our learned opposing counsels. The counsel for the respondents claimed that the parties were identical because the claimant and the shareholders were privies to each other, and so they would be identical in that sense and would fall under the res judicata doctrine. However, panel of arbitrators, we wish to rebut this by raising the case of Escosol and Italy, a 2020 decision, whereby the tribunal stated that the concept of privity is peculiar to common law and is not really to be applied in international law. And moreover, counsel for the respondent stated that Donald and Daisy were controlling shareholders, and this further solidifies the fact that they were privies to the company. However, on that point of control, we would argue that Donald and Daisy are not controlling shareholders, number one, because the facts do not indicate that at all, and number two, based on the Aguas del Tunari and Bolivia Exit Tribunal decision in 2005, there is no presumption of control when the claim is brought by majority shareholders. Only if the shareholders own 100%, then there would be a presumption of control. Even then, the test would be effective control, where the shareholders would have some level of dominance over the decision making. But we wish to rebut this with our application that here, Donald and Daisy collectively own 75% of the shares, and so they would not be identical parties with the claimant.
What about the respondent's argument here then, that they must have somehow known at least, because they held such a large percentage of shareholding in a way that would make them implicitly consent or control or direct that proceeding against the respondent?
Thank you for the question, Arbitrator Ian. We acknowledge that the claimants raised that argument. However, the respondents admitted that there is no coordination between the parties according to the moot problem, and merely alluded to the fact that there is a mere possibility that there was some sort of coordination between the parties. But then we would argue in the opposite, whereby there was no knowledge on the part of the claimant company, even that Donald and Daisy brought the exit decision in the first place. And so in that sense, there is no coordination between the claimant and the shareholders. On the second limb of identity of object and cause of action, learned counsel for the respondents argued them together, and so I will do so as well. Here, on the point of identity of object and cause of action, we would argue that both limbs have also not been fulfilled. In the Delgado claims case in the US Spanish Claim Commission, there were two claims as well. The first was for damages for the seized property, while the second claim was for damages of the value of the property that was seized. And in that case, they were essentially the same object. But applying that to our previous circumstances, Donald and Daisy brought an action for compensation on the basis of Article 7 of the BIT, while currently they are bringing an action for moral damages, war loss compensation, and are claiming that there is a breach of the full protection and security obligation. And this is on the basis of Article 5 of the BIT. Moreover, in terms of identity of cause of action, Donald and Daisy brought a claim for indirect expropriation, which requires a totally different legal standard, which is substantial deprivation of the assets. And currently it is for FPS, war loss compensation, and moral damages. Here, the respondents stated that essentially both claims emanate from the same breach, and we understand that. However, we wish to raise the dissenting judgment of Judge Anzilotti in the Chozao factory case, whereby he says that it is necessary to view differently the same facts in different suits because different principles would apply. And so on that basis, we would argue that this tribunal has jurisdiction because the res judicata doctrine does not apply. Panel of arbitrators. I now move on to our arguments that this tribunal has jurisdiction, despite the fact that the claimants have not exhausted local remedies. Our arguments will be twofold. The first is that the futility exception does apply in the present circumstances, despite it not being expressly mentioned in Article 12 of the BIT. Excuse me. And secondly, that it would have been futile for the claimants to bring their claim before the Rakian courts. As for the first limb, we acknowledge the respondents' arguments that the host state ought to have recourse, be able to defend themselves in the local courts, and that would have been the intention of the parties during the crafting of the BIT. We acknowledge that. However, if we look at Article 12 of the BIT, despite the fact that there is a lack of any exception in the form of futility, it is also pertinent to note that Article 12 does not prohibit or restrict the applicability or the utilization of the futility exception. And so this absence of this wording infers the need to interpret the BIT in line with the international legal standard, in line with Article 31, Clause 3 of the VCLT, whereby the treaty ought to be interpreted in line with the relevant rules of law applicable. And this was also applied in the Ambiente and Argentine Republic case, an exit tribunal decision in the year 2013, whereby it was stated that this exception to the exhaustion of local remedies rule in terms of futility is universally recognized, not just in the law of diplomatic protection, but also in international investment law. And this was also accepted in the draft articles of the International Law Commission on diplomatic protection in the year 2006. And so it is important to note that even though it was just mentioned in the context of diplomatic law, the tribunal went on to state that it is not far-fetched to assume the futility exception to international investment law. And this is not just peculiar to Ambiente, and Argentine Republic, but it was also supported in other cases of the exit tribunal, like Bywater Gulf in Tanzania and Saipem and Bangladesh. Now we wish to proceed to the limit that it would have been futile for the claimants to have attempted to bring the claim before the local Rakian courts. The counsel for the respondents stated that futility does not apply due to a lack of undue delay. And in our argument, we wish to state that it would not only have been futile, but it would have defeated the object and the purpose of the BIT, which is to promote further investment and to strengthen the economic relationship between the parties. And so, as correctly pointed out by the counsel for the respondents, in Ambiente, 3 cases were laid down. The first is the test of obvious futility, where the parties would need to explain that seeking a claim before local courts would be patently unavailable and completely ineffective. But the tribunal labeled this test as being too high a standard. The second test, on the other hand, was too low a standard, whereby the standard was that there is no reasonable prospect of success. The standard was found to favor the claimant too much, and that is why we wish to adopt the third test, which is a very reasonable test. And this test was stated first by the International Law Commission, and it was adopted in Ambiente and the Argentine Republic. And this test is that this tribunal needs to establish whether the municipal system is reasonably capable of providing effective relief. Now, we understand the concerns of the respondent that Ambiente can be contrasted from our case because there had been a legislation in place that would essentially make it impossible for the parties to bring a claim. But despite the lack of a legislation here, we still wish to raise this case because this position is highly authoritative, despite not being binding, because it has been also highly supported by the International Law Commission. Here, the counsel for the respondents stated that there is no evidence of, like, in the form of previous cases whereby the court deliberately delayed the proceedings, and therefore the respondents reached the conclusion that there is no undue delay. But we wish to agree with the point put forth by Arbitrator Ian that it would just be pointless to bring a claim to the local court just so that we could wait for the 18 months to lapse and then bring a claim before this tribunal.
On this note, since I called, I just wanted to ask, since it appears to me that the situation was improving, you now have virtual hearings, and as of January 2021, the time to be heard at first instance was 12 months from 16. So given the state of improvement, why didn't your client even try to pursue a claim in June 2021? You say that the test is reasonable possibility. Isn't it reasonably possible that things could have further improved and the backlog could have been cleared?
Arbitrator Ian, we take note of your concerns. In fact, the respondent too mentioned that the average is now 12 months instead of 16 to 18 months. And we also take note that there has been a use of technology and a use of virtual hearings and so on to reply to the 12-month timeline. We must acknowledge that this is merely an average, and it takes into account the expedited process in the local courts, which we would argue the claimants would not fall under the expedited process because it is designed in such a way for cases that can be of low complexity, whereby the duration of the trial can be shortened, lesser documents can be admitted, and so on. But we would argue that our case would not fall under that because our case is far from simple. It involves a claim for a breach of full protection and security, a claim for moral damages, and war loss compensation. On the point that technology has been incorporated into the local courts, we take note of that. But in reference to page 63 of the moot problem, specifically paragraph 24, it states that after technology had been incorporated into the local courts, there was a heavier and more complex caseload, involving sophisticated commercial disputes, and the backlog in cases is not part of history. It continues to this day. And this is actually originating from the statement of uncontested facts as of 9th of January 2022. And so this is a very present reality. Moreover, it is pertinent to note that the local courts are prioritizing criminal cases. And so considering how this is a commercial case involving investment, therefore it would not qualify as being part of the expedited process, and neither would it be part of the leapfrog procedure. And so with that, seeing that my time is about to lapse, I wish to conclude my arguments by stating that this tribunal has jurisdiction because the res judicata doctrine does not apply, and despite the fact that the claimants have not exhausted local remedies. Thank you, panel of arbitrators.
Co-arbitrators, do you have any further questions before we move on to the next step? Okay. Okay, Council, can we proceed on the next issue, please?
Sorry, members of the tribunal, do I proceed with my rebuttals at this point?
Yes.
All right, thank you very much. Members of the tribunal, counsel for claimant has stated that the futility exception applies due to time delay. And however, they also stated that the average time for a case to be heard at first instance was 12 months, but assumed that their case would be so complex that they wouldn't want to use the expedited procedure. However, if the tribunal will look at procedural order number 3 at paragraph 9 at page 90 of the agreed bundle at the bottom of the page, the claimants can agree to the mechanisms that they want such that the complexity of their case is not skimmed over. Furthermore, this period of 18 months does not require for there to be a full judgment. The claimants could have just filed a case and waited 18 months. If the case was not heard, they could go to arbitration quite easily. The respondent simply wants the BIT to be stuck to as much as possible. If there are no further questions, I note that my time is up and conclude my rebuttals.
Okay. Claimant, your rebuttal, please.
Panel of arbitrators, 2 points of rebuttal regarding the first claim by the respondents that the claimants can resort to the expedited process. We would argue that that is not true because this case is complex. It involves the full protection and security, moral damages, and war loss compensation claim. And therefore, it is not possible for the claim to be heard within 12 months, despite the average that is being put forth. Secondly, as to the suggestion that the claimants wait 18 months and just bring the claim before local courts and then only bring the claim before this arbitral tribunal, we wish to submit that it would be useless and nugatory because it would just amount to the claimants not being able to get the relief that they deserve due to the respondents' breaches of the BIT. And with that, I conclude our rebuttals. Thank you.
Mr. Lee, Mr. Chiang, questions? Okay. Ian, could I ask you a favor? Could you oversee the administrative aspect of on this and ask counsel to move forward with the next issues, please?
Good day, panel of arbitrators. My name is Harsha Kaur, appearing on behalf of the claimants. I will address 3 issues. First is the breach of the full protection and security standard under Article 5. Second is the issue of compensation under Article 6. And finally, the claim for moral damages. I'll spend 19 minutes to address the merits of this case and reserve 1 minute for rebuttals. The first issue addressed is the respondents have breached the full protection and security standard under Article 5 of the BIT. The full protection and security standard should be evaluated in light of whether the host state has exercised due diligence in protecting the claimant's investment. Based on the 2011 Untitled case of Hyuk against Mongolia, the tribunal found two qualifying tests to satisfy the obligation of due diligence. First is the duty of prevention, and second is the duty of repression. It is observed that the primary duty of a state is to prevent wrongful injuries to investors, to prevent injuries to its investors or its property, and failing to do so, they have a secondary duty to at least exercise due diligence to punish such injuries. To put it simply, Rakia has failed to afford certain investments physical and legal protection, and this forms the foundation of the claimant's arguments on this ground. I would like to address a preliminary point raised in the respondent's skeletal, stating that the claimants chose to invest in an unstable environment, therefore they should assume the risk of injury to their investment. On this note, despite Rakia facing a certain degree of political turbulence, it always welcomed investors and said that it is firmly committed to provide stability and to meet all obligations owed to its investors under the BIT.
Counsel.
Moving on.
Counsel, quick question. The notion of quote unquote guarantee FPS, full protection and services, is that what you are arguing? Or how do you reconcile between the realistic protection that could be afforded by a host state versus, say, a quote unquote a notion of guarantee that a certain investment into a foreign sovereignty could result in a positive result?
Presiding Arbitrator, the claimants are adopting the threshold of due diligence where this tribunal should assess and consider the surrounding circumstances of the state of Rakia. We are not adopting the standard as propounded, for example, in the case of AAPL against Sri Lanka, where the threshold for full protection and security is higher because the threshold is what a well-administered government would do. We are adopting cases that provides that the consideration on all surrounding circumstances and resources have to be considered. This brings me to my first sub-argument on the failure to provide physical protection to certain investments. The respondents are arguing that the civil unrest or war significantly lowers the standards of due diligence, and we agree with this. Now, relying on the 2016 exit case of MNSS against Montenegro, the tribunal found it surprising that the government ignored requests for police protection, especially since the full protection and security standard requires a state to act proactively to secure protection of the property once it has been warned by the investors of the possibility of a violation. Now, despite receiving written requests from certain investments and from media reports, the government took no immediate action to offer assistance to the claimants. However, bringing this tribunal's attention to page 29, which is page 31 of the record, specifically paragraph 8. My apologies, it's page 32. Mr. Rokari held a meeting with both of certain investments competitors in the cannabis industry to discuss their concerns over their investments. Therefore, to address the respondents' argument that the respondents had to prioritize its military efforts at other locations, this set of facts makes it clear that Rakia chose not to proactively protect certain investments. At the Freya plant, the respondents are attempting to argue that they were only aware of the risk of injury when Freya was looted and ransacked. However, they failed to deploy defense units immediately. In the 2000 exit case of Wina Hotels against Egypt, the tribunal found a breach of the full protection and security standard because Egypt failed to take effective measures after becoming aware of the risk of injury. The respondent's contention here is that there's an inability to protect would not amount to a breach of the full protection and security standard However, panel of arbitrators, Freya was attacked by a small number of armed militia over the course of 3 days. But Rekia only mobilized troops 2 days after the attack. These measures are unreasonable because the armed militia were using weaponry ranging from gunfire to incendiary devices such as gasoline bombs. The respondents have failed to place any urgency on the situation. At the Odin plant, the respondents may argue that it took preemptory measures because they stationed troops at the plant. The claimants would debunk this line of argument based on the 2017 exit case of Ampal American against Egypt, where the tribunal found a breach of the full protection and security clause because the military troops had either abandoned the area or were preoccupied elsewhere. Similarly, in our case, during the time Odin was attacked, the military were engaged at other areas, and this is found on page 94, paragraph 11 of the moot problem. It further states that the respondents failed to even inform Sutton Investments that it was requisitioning the Odin plant to build garrisons and fortification. Therefore, the respondents merely used Odin for their own benefit and did not have the intention of protecting the plant after Freya was attacked. Going on to the issue of detonating the Odin plant, it is the
Counsel, just before you go there, just maybe I can ask you a few questions on this. So first of all, you cited the case of Rubina Hotels. I just wanted to understand, isn't it true that the time span and the timeline of events in the Rubina Hotels was significantly longer? So it took place over many more days and weeks. And over here, we're talking about a delay of perhaps 1 or 2 days before the respondents' forces acted. And my second question is, based on Mr. Rokari's press statement, it seems that the government made a judgment call as to how to best use its limited resources. To what extent do we take into consideration deference to the state in adjudicating matters like this in a civil conflict?
Arbitrator Ian, if I may address the second question first. Mr. Rokari held meetings with Mr. Budd and Mr. High Mountain, who are both players in the cannabis industry in Reykjavik. They could have easily included Sutton Investments, who have repeatedly sent requests to them to hold a meeting and discuss the situation of the civil strife.
So are you alleging discrimination then? And if you are, do you have positive evidence of such discrimination?
Arbitrator Ian, our contention here is not that the claimants have been discriminated, merely because this issue would then fall under the fair and equitable treatment standard. Our contention here is that they were warned, they were aware of the risk, and they took no measures to circumvent it, but they engaged with the competitors to help them out. And this is inaction and inadequacy of action that amounts to a breach. If I may go back to the first question that was posed on the timeline in Wena Hotels, we acknowledge that the circumstances between two cases are not entirely the same. However, we have to go back to the fact that the first instance of attack is when Freya was looted and ransacked, not the first day that the Freya plant was attacked by the armed militia. And secondly, the urgency of the situation, because the armed militia had used weaponry and they had destroyed the entire plant over the course of 3 days. Therefore, we must look at the effectiveness of the government's measure. Moving on with my submission to talk about the detonation of the Odin plant, we submit that it is the opposite of providing full protection and security. The respondents will attempt to justify the act by stating that they only destroyed buildings capable of agricultural production. But the truth is, they destroyed the entire Odin plant because the entire plant is capable of food production. There is no reasonable justification for only detonating the Odin plant when Reykjavik is an agricultural country lush with vegetation, and specifically because Odin plant is hugging mountains sufficient to provide food supplies to the rebels. Moving on to the secondary obligation, the state of Reykjavik has failed the duty of repression. And on this argument, the claimant submits 2 points. First, In some places, Rakia's military refused to fight the rebels and instead defected, which increased the level of instability throughout the country. Now, bringing this tribunal's attention to page 24 of the record, paragraph 5, the Rakian government acknowledged the frequent defection, and they guaranteed its investors and the international community that it is committed to investigating all individuals suspected of involvement, and they would be punished to the fullest extent of the law. However, if we go to page 92, paragraph 20, the government of Rakia did not conduct investigations against any other entity in relation to links with the militia. Therefore, they failed to prosecute and hold those accountable for injuring certain investments. And this concludes my submission on ground 3, that Rakia has not taken reasonable and adequate measures to protect the physical integrity of certain investments. I will now move on to the issue of compensation for war losses under Article 6 of the BIT. The claimants will put forth 2 arguments. The first is that Article 6 of the BIT does not override Article 5. And second, Article 6, Clause 2 acts as a lex specialis over Article 6, Clause 1 of the BIT. On the first argument, we rely on the 2020 ICSID case of Strabag against Libya, where the tribunal found that states that intend certain provisions to have limited effect or operate to the exclusion of other provisions have the means to make this clear. Had the treaty parties intended for Article 6 to operate as an exclusion of other provisions, they could have said so. And in the present case, nothing in Article 6 suggests that nothing in Article 5 suggests that it ceases altogether to apply in times of armed conflict. Going on to my second argument, Article 6, Clause 2 is a lex specialis. Therefore, it overrides the effect of Article 6, Clause 1. Panel of Arbitrators, Article 6, Clause 2 addresses 2 specific scenarios. First is the requisitioning of property by the authorities, or second is the destruction of properties by forces of the state, which is either not caused in combat or it is not justified by the necessity of the situation. Upon construction, the tribunal in AAPL against Sri Lanka pointed out that Clause 2 would act as a lex specialis over Clause 1 because it spells out the specific grounds of liability in a particular situation. Therefore, it should prevail as the definitive and exhaustive source of liability in respect to the conduct of the armed forces. And this brings me to the second point of this argument. The claimants are entitled to compensation upon proving the elements under Article 6, Clause 2. Namely, the destruction is attributable to the respondent, and secondly, either the destruction was not caused in combat or it's not justified by the necessity of the situation. On the first element of attribution, the claimants would like to bring this tribunal's attention to page 24, specifically paragraph 5. If the tribunal is with me, Rakia does not dispute any international responsibility that arises from any wrongdoing attributed to it. The claimants have addressed all of Rakia's wrongdoings towards certain investment in failing to provide full protection and security. Further, in the 2007 UNCITRAL case of Eastern Sugar against Czech Republic, the tribunal found that the full protection and security standard extends to actions of third parties. Therefore, I will move on to the second element, that the destruction was not caused in combat. First, the Freya plant was destroyed by the armed militia. But now for the Odin plant, the Rakian military were not attacked or in combat with the rebels. In fact, there's a striking contrast between what happened at the Freya plant and what happened at the Odin plant. First, at the Freya plant, there was no coordinated attack by the armed militia. And second, the armed militia did not use weaponry or violence around the Odin plant. Therefore, the claimants were not under attack or in combat. Alternatively, the claimants submit that the actions of detonating the Odin plant is not justified by necessity. Members of this tribunal, scorched earth tactics is specifically prohibited under Article 54, Clause 2, of the additional protocol, which reads that it is prohibited to attack, destroy, remove, or render useless objects indispensable to the survival of civilian population, such as foodstuff or agricultural areas for the production of foodstuff or crops, for the sole purpose of denying them sustenance value to the adverse party. In our case, that would be the armed militia, regardless of the motive. I've explained the surrounding circumstances at the Odin plant and that this plant is capable of agriculture production. Although its purpose built for cannabis, minor adjustments would allow cultivation of food crops. And finally, to rebut the respondents' contention that non-precluded measures employed on certain investments were necessary for the protection of their own essential security interests and was triggered by military objectives, the claimants would like to highlight that detonating the Odin plant was not the only way to combat the armed militia. There are two alternatives that we can offer. First, using the same emergency airlift to replenish food and supplies to the troops, or secondly, using the same tactic to employ more troops to the plant. This concludes our
Excuse me,
submission.
Counsel. I have a question regarding the detonation of the Odin plant. So, wouldn't it be more reasonable for this tribunal to rely on the decision making of the armed forces rather than a commercial party who is an investor in this case? Because it was more of a military decision rather than a commercial decision to detonate the Odin plant.
Arbitrator Lee, thank you for the question. Even if we were to assess what was going through the minds of the military in Reykjavik at the time of detonating, the sole reason that they have detonated the plant is because the plant would provide food supplies to the armed militia and they wanted to stop the civil war. However, the civil war didn't stop for another 6 months because the armistice was only called in April 2017, which proves that the tactic was not a fruitful tactic. In the interest of time, panel of arbitrators, I'll advance to the third ground on moral damages. We submit that moral damages should be granted, and we have one point to make. There is a causal link between Reykjav's unlawful act and the alleged damage. Now, the ICJ in the Diallo case has defined moral damages to mean harm other than material injury which is suffered by the injured entity or individual. The respondents might rely on the case of Lemire against Ukraine. However, if we refer to the Arif against Moldova tribunal, it has concluded that the test in Lemire in Ukraine must be seen as a disjunctive test. And the reason, because the cumulative test is only specific to the Lemire case. We will put forth three arguments on the causal link. The first is that the claimant's reputation was harmed not only in Reykjavik, but with their business counterparts in other countries. Secondly, the bank loan was rejected. At the same time, the Reykjavik government made the allegation that the cannabis industry is being investigated. And finally, the undersubscription of equity is also because of the Reykjavik government's comments and active investigation. If there are no further questions, the claimants would end their submission here. Thank you.
Just a quick question. Does the state not have a right to announce that an individual or a company is the subject of criminal investigations? Isn't there some sort of public interest in that?
Arbitrator Ian, yes, a state can disclose that they probably have an ongoing investigation on a certain individual. But I've referred this tribunal to a certain part of the facts that says Reykjavik stopped all investigations against all individuals and entities. So basically, it would show that these allegations are baseless. And if we rely on the case of Al-Kharafi against Libya, the tribunal awarded moral damages for the injury caused on worldwide professional reputation, such as global businesses. And that has occurred to the claimants in our case today. Thank you very much.
Thank you, counsel. Rebuttal, please.
Members of the tribunal, before I begin, may I check if I'm audible?
Yes.
Thank you. May it please this tribunal, my name is Jerome and I represent the respondents in today's proceedings. I'll be assisting this tribunal with the issues on the merits and accordingly raised 3 submissions. Firstly, the respondent has not breached its obligation under Article 5 to provide full protection and security to the claimant's investments. Secondly, even if this tribunal finds that the respondent has breached its FPS obligations, the compensation for war losses clause in Article 6 operates to preclude the claimant from receiving compensation. Thirdly, even if the claimant is entitled to compensation, they are not entitled to moral damages. Now, turning to our first submission, we will first begin with the law on FPS before applying it to the facts of Freya and Odin. The respondent respectfully asks this tribunal to bear 2 things in mind in applying the FPS standard. Firstly, as the claimant has acknowledged in their skeletals, the FPS standard to be applied here is the international minimum standard. Cases such as the 2015 exit case Adel A. Hamadi and Oman have noted that the minimum standard imposes a very high bar for breach, and it would generally involve willful or egregious failure by the state. Now, the second thing to bear in mind is that the FPS standard imposes an obligation of due diligence, which is itself modified to fit the circumstances of the host state. Now, we are not saying that just because the claimant has chosen to invest in a less developed country, that the host state is immune from liability. What we are instead saying is that in practical terms, the host state's resources must be kept in mind when the tribunal assesses the reasonableness of its measures. What this means is that an investor who chooses to invest in a state with more limited resources, such as Reykjavik, cannot expect the same level of physical security and support, at least in absolute terms, as they would if they had invested in a more developed area, such as New York or Tokyo. Now, members of the tribunal, turning first to the facts of Freya, the claimant's case hinges primarily on how the harm should have been predictable, and they rely on the warnings issued by the claimant to Mr. Rokari, as well as the request for meetings. And we'll take these assertions in turn. Now, firstly, the attacks were not so foreseeable that the respondent should have had to allocate troops beforehand. If I may refer to the authorities, cases such as Rina in Egypt involve the direct threat by the local public entity to repossess the hotel property through force. In the 2017 exit case, Ampal in Egypt, the claim concerned a pipeline that was attacked 13 times by terrorists. While we note that the claimant has cited Ampal as well to show that the foreseeability of an attack should oblige the state to respond, we would also note that the tribunal in Ampal observed that the first 4 attacks should have been seen as a warning to the state. Now, what these 2 authorities show us is that the level of predictability that is required before a state is obliged to act is very high. In the present case, there was no evidence of a direct threat from the militia, and the best that the respondent could work off were speculations by the claimant. Now, notwithstanding that the claimant made multiple requests for assistance, we submit that this is not enough. During a civil war, many stakeholders would have requested protection from the state. In the absence of direct evidence of an imminent attack, the claimant's fears were at the time largely speculative. The respondent cannot be expected to respond to every single request for assistance without considering whether these concerns would eventually materialize. The claimant also references the fact that they were not given meetings while their competitors were. As a general rule, the respondent would point out that investors have no right of audience with host states. Secondly, it is not as if the respondent paid no heed to the claimant's concerns. We did, in fact, preemptively allocate some of our best troops to the claimant's plants in Odin. However, given our limited resources, we made the judgment call that we could not allocate troops to both Freya and Odin, and decided instead to allocate our remaining troops to more important areas such as the financial districts and areas where the government and civil service are based. Now, this brings me to my second point, that a state should be entitled to consider the relative importance of the interests it seeks to protect when allocating resources. As the claimant had, apologies.
Excuse me, counsel.
Yes, Mr. Arbitrator.
So it sounds like the respondent admits the fact, no, not the fact, excuse me, admits that the respondent did not have enough resources to provide the complete protection of the both plants, right? So if that is the judgment call that you just mentioned, would it be part of the so-called due diligence to communicate with the claimant regarding the situation and your incapacity to provide the protection to both plants?
Mr. Arbitrator, I acknowledge your concern, and it would definitely be best practice to communicate every decision to the claimant. However, if I may refer this tribunal to page 28 of the bundle, I believe that would be page 31 of the PDF. Members of the tribunal, may I check if you are with me? Thank you. At paragraph 8, at the bottom of the paragraph, Mr. Rokari mentions how the volatility of the situation and the confidentiality of the respondents' decisions are, especially military decisions, are some things that have to be taken into account. At paragraph 5 on page 28, this is the preceding page, the respondent's Home Affairs Minister also says that they are unable to disclose further details regarding the military's allocation of its resources. And so, considering also the fact that there have been rumors as to the claimant's alleged links with the militia, I think it is completely reasonable that the respondent did not ultimately communicate its military allocations to the claimant. Not denying that that would have been best practice, but it was a judgment call we made in the end. Members of the tribunal, turning... yes, Mr. President.
Just a quick question. You had referred to a case where there were multiple attacks on a pipeline, and the first 4 attacks needed to happen in order for a level of predictability to rise, which would require the whole state to actually provide a certain amount of protection. Now, could you just provide your respondent's view on reconciling that versus a realistic possibility that it may not be 4 attacks, it may just be 1 or 2 attacks that would simply demolish any investor's physical property? How would you reconcile where the level of host state's obligation starts?
Certainly, Mr. President. I do acknowledge that requiring multiple attacks to happen first does seem like a rather extreme position. And I do not think we intend to rely on this case as setting an absolute threshold. Rather, what we intended to rely on the case for was merely to show that in the circumstances of armed conflict and rapidly changing scenarios, the state cannot be obliged to make decisions and allocations of mere speculation. Rather, there should be some level of foreseeability before the state is required to act. And we would submit that what is required is a direct threat of imminent attack. So other cases where this has happened include where the militia or the terrorist group in question actually sent a threat to the militia group, and that threat was taken seriously. Members of the tribunal...
Would it also matter if at page 90, Odin and Freya are the largest cannabis plants, and wouldn't it mean that it would be quite foreseeable, right? There was already 1 attack, and you have this anti-cannabis agenda, and then these 2 plants are the largest. Taken together, shouldn't states sort of have seen it coming? Wouldn't there have been signs already?
Mr. Arbitrator, I acknowledge the anti-cannabis nature of the civil war, but I mean, there might be many reasons why a plant would be attacked. It is entirely possible that some plants are more easily reachable by the militia than others. And we do note that we did preemptively allocate troops to Odin, which was in a more isolated location and which was harder to defend. In the circumstances, the respondent clearly believed that responding to the attack within 48 hours would have been enough to wave off any potential attack by the militia. And if this addresses Mr. Arbitrator's concerns, I know that my time is, that in the interest of time, I'll address Odin briefly before turning to the remaining of my submissions. Now, regarding the facts of Odin, the claimant notes that the respondent's decision to destroy the plant was, quote, fruitless because, as in the tactic was fruitless because the plant was ultimately destroyed. But with respect, the test is not whether the tactic would have ultimately resulted in complete military success for the respondent. Instead, the test is whether a commander on the ground would have had a reasonable suspicion as to the purpose and use of the objective in question, such that it could be considered a military objective and it could be validly destroyed under principles of international humanitarian law. And in our case, we submit that this has been satisfied. If I may turn the tribunal with us to page 64 of the agreed bundle, this is at page 67 of the PDF, at paragraphs 43 and 44. May I check if the tribunal is with me? Thank you. These two paragraphs reveal a series of events where the rebels are interested in seizing food, and where there has been an insufficient supply of food, their push has been slowed down. The irresistible inference from the series of events and the fact that Odin would be able to grow food with a few adjustments is that the militia was interested to seize the plant in order to convert it to produce food for the war effort. And in these circumstances, I think some measure of deference must be given to the commander on the ground, who believed that it was necessary to destroy these buildings before they turned over into the hands of the rebels. Notwithstanding that this might not have led to the complete end of the civil war, it cannot be that just because one military decision does not lead to a definitive outcome, that it was not taken in a military context or that it was not required in the circumstances. Ultimate success is the result of multiple military decisions. Members of the tribunal, turning quickly to our submissions on the compensation for war losses clause. If I may turn this tribunal with us to page 75 of the agreed bundle. This is page 78 of the PDF. Now, our submission on Article 6.1 is that even if this tribunal finds the respondent liable for a breach of the FPS obligation, Article 6.1 operates lex specialis to preclude the claimant from receiving compensation. We note that the claimant has cited a number of Argentinian cases which have interpreted 6.1 as merely supplementing existing obligations, but we would submit that the case law is not entirely clear. Other cases, such as Lessie and Algeria, citing the dissenting opinion in AAPL and Sri Lanka, have adopted the respondent's position that when a situation falls within the circumstances of Article 6.1, the respondent's obligations are essentially restricted to what is provided within this paragraph, and that is non-discriminatory treatment in the matters of compensation. And we would submit that our position is to be preferred so as to give effect to Article 6.1 in light of the existing non-discriminatory obligations. Now, if I may turn the tribunal's attention to the preceding page, this is page 74 of the bundle. We will note that Articles 3 and 4 of the BIT already provide for non-discriminatory treatment in respect of all matters, essentially all matters governing investments. Now, we would submit that if we were to adopt the claimant's interpretation, Article 6.1 would essentially become devoid of meaning because it would simply be a repetition of the existing obligations under Articles 3 and 4, but in the more specified circumstance of losses suffered due to armed conflict. Therefore, the respondent's interpretation, which operates both ways, also operating to protect the respondent, should be preferred so as to give effect to Article 6.1. We also note the claimant has brought up Article 6.2b to, even in the event that Article 6.1 applies, but we would submit for the same reasons already discussed earlier with regard to our measures at Odin, that we do fall within the military actions taken out of necessity, and therefore Article 6.2b does not apply in our present case as well. Sorry, Mr. Arbitrator. So,
I note your point on deference, but with regard to the actions at Odin, it seems to me that if we are to give any meaningful protection to the investors, necessity needs to be, I think, quite a high threshold. So it seems to us that the actions of the state were quite prophylactic. You burned everything because you thought they would convert it for agricultural usage. Isn't that insufficient to be necessary?
Mr. Arbitrator, we would submit that certainly prophylactic decisions wouldn't be, the mere fact that the decision is prophylactic shouldn't cross the threshold of necessity. What we have to look at is the particular facts of the case, and in these circumstances, we submit that the irresistible inference of the militia's intention was to use the plant as a place for future agricultural production. Considering that the evidence is so strong of an imminent intention to use it to grow food and for the war effort, I think it would also be artificial for the respondent to have to wait until the plant is converted, until the plant is actually applied to the war effort before it can be destroyed, especially considering that there is no guarantee that the respondent would be able to take it, to recapture the plant at any future date. Members of the tribunal, in the interest of time, and quickly turning to my last submission, even if you are not with the respondent on the first two issues, we submit that moral damages are not warranted in this situation. Now, we note that the claimant has cited the case of Frank Charles Arif and Moldova as authority for not strictly following the requirements in the MER's conjunctive set of requirements. However, we also note that at paragraph 591 of Frank Charles Arif, the tribunal still adopted the general framework that moral damages are an exceptional remedy. And this requirement of exceptionality has been consistently upheld in Lemire and Ukraine and in other cases such as Desert Line. In the present case, the facts do not come close to any level of exceptionality before moral damages can be awarded. We note that what we have here is a seasoned investor subject to a single investigation in a country which is not particularly known for political stability, In the circumstances, we submit that our actions, even if attributable to us, were not so exceptional as to warrant moral damages. Members of the tribunal, I note my time has expired, and unless I may be of further assistance, I've come to the end of my submissions. Thank you.
Thank you. Counsel, claimant.
Panel of arbitrators, 2 points of rebuttal. First, the respondents are contending that the attacks were not foreseeable. Based on the case of Ampal American against Egypt, first attacks should be seen as a warning that further attacks would be carried out if security measures are not taken. The failure of authorities to take any concrete steps to protect the claimant's investment from damage would amount to a breach. The respondent's argument is that the warning and foreseeability of attacks only became apparent once the armed militia were using weapons and detonating the Freya plant, and this is unreasonable, considering page 94, paragraph 5, which states that Freya and Odin suffered the largest instance of investment destruction, and what more when Rican soldiers employed scorched earth tactics. On the second point of rebuttal, we rely on the case of Giris against Libya, which held that war laws clauses do not derogate treaty rights, but merely ensures any measures directed at offsetting or minimizing losses will be applied in a non-discriminatory manner. In simple words, panel of arbitrators, essentially clause 1 especially guarantees equal payment, not equal non-payment. Thank you.
Thank you, counsel.
Thank you, Mr. President. Similarly, 2 points of rebuttal for the respondent. Firstly, the claimant highlights the fact that the respondent did not take any concrete steps to protect the plant in Freya. But we again reiterate that there must be a certain level of foreseeability that is reached before concrete steps are taken. We cannot be expected to respond to any request for assistance, regardless of how predictable or not the harm is. Now, secondly, on the war losses clause, we do acknowledge that there are authorities supporting the claimant's position. But again, this has not been entirely settled in the case law, and for the reasons of effectiveness that we have earlier raised, we submit that Article 6.1 should be interpreted in a manner that provides protection both ways, to both the claimant and the respondent, such that it is not devoid of meaning in this BIT. Members of the tribunal, unless there are further questions, come to the end of my rebuttals. Thank you.
Counsel, apologies. I know we're running short on time, but just a quick question on the allegation that made by your client that claimant was somehow in tie with the rebels, which then resulted in a number of other issues, basically undersubscription of the new shares being issued, the bank loans not being given, and all of that. Could you reconcile that with the moral damages issue here that you had advocated that it does not apply?
Mr. President, if I may take your questions in turn. Firstly, on the allegations by Rakian leaders that the cannabis industry is in cahoots with the militia, we note that the facts simply suggest that these were politicians essentially making political statements, and they do not represent any official statement on behalf of the Rakian government. Secondly, with regard to the bank loan, if I may turn the tribunal's attention to page 18 of the agreed bundle. This is at page 21 of the PDF. May I check if the tribunal is with me? Thank you. In the second paragraph of the loan application letter, we note that the bank also cites examinations of the claimant's enterprise and their financial standing as reasons why they did not extend a line of credit at this time. While we acknowledge that the bank did cite the possibility of civil and criminal sanctions, this letter and the facts suggest that this was not the only reason why the line of credit was denied, considering that the claimant has just come out of a civil war with their investments being destroyed, and in an unstable market of cannabis, particularly in this country, there are multiple reasons why the loan application is denied, and it cannot be completely attributable to the whole state. Mr. President, if that answers your questions, I've come to the end of my submissions. Thank you.
Thank you very much, counsel. Arbitrator Lee and Arbitrator Chiang, any last comments? Okay, thank you. Thank you, counsel, for your time and your explanation on behalf of your clients. Christian, may I ask what the next administrative step would be, please?
Yes, we will move the arbitrators to chambers so they can deliberate on the decision that they have to make, and the teams will wait here, and then we'll bring you back and have the award ceremony and you can announce your decision.
Thank you. Thank you, counsel. As per Mr. Campbell's instructions, the tribunal will then move to a separate chambers to deliberate.
In fact, I believe you can, if you click the 3 dots at the bottom and breakout rooms, I think you'll have the option to join chambers 1 already there, to return to the breakout room.
I see. Understood.
And Christian, where do we go? Myself and Frederick?
Right, and we have a chambers 1A, I thought, Manuela, do we not? Yes,
Yes,
we
yes, I
will
see
move
that.
you. We will move you to chambers 1A. If you, I believe you also have the option to just do that as
Yeah,
well.
I can do that.
Right, and then
Thank
you can. Thank you. Thank you. And the teams can hang out here and relax a little bit. And we're also going to start admitting some of the other teams into the meeting that have advocates that will also be honored today as well, in addition to the winners of the final and the 3rd place match. But you can relax, you can let your hair down for a moment, I suppose, so to speak.
Thanks for the round, Team Wellington. It was quite enjoyable.
Good job, you guys. Like, it was a very good round.
Yeah, the final and the semifinals are always really very good, very interesting, very high level.
Thank you, Mr. Campbell. Thank you.
You'll also you know, so now that essentially the competition of the regional round is concluded, the teams will also be able to reveal, and will be revealing on the slides that will be shared during the award ceremony, your actual university affiliations, so you can also identify yourselves if you'd like, for the audience, and that you're not just Wellington, but you're not just Kirsch, but you actually are connected with the university that I assume is proud of you, and you are perhaps also proud of them. So let me.
Mr. Campbell, is it permissible for us to just switch off our?
Sure, you can switch off your video for now. I think we're going to give them about 5 or 6 minutes to think, and we might start the award ceremony before they're actually done, because we have some advocates to honor as well, and then we'd like you to turn it back on again when you hear your name, either in the context of the final match, but also, of course, if you hear it in the context of the advocates who are being specifically honored in regard to the group phase from last weekend. So, but meanwhile, you can turn your camera off, mute your mic, and relax.